All right, I want to deal first with the question of costs. Mr. Kuksal, I've not received any material or the other defendants in response to the board's application for costs. And last year, before you got here, Ms. Norton was confirming that they've not received anything. Is that the position?
Your Honor, we sought leave to file evidence. Essentially, there were multiple proceedings.
I'm just dealing with the question of the costs.
Yes, and I'm addressing that question.
I just want to clarify, first of all, you haven't filed. You can explain why in a moment, but
we haven't filed, we say it's a question that goes to evidence. The starting point in this matter is whether or not there is in fact a proceeding that's live. That matter was not settled by Her Honor Justice Forbes. Your Honor would appreciate that while filing or commencing the proceedings, the LSB had relied on a provision that allows the court to permit a modified or an exceptional originating process, not the usual written summons, and the court needs to give them leave to commence the proceeding the way they have sought to commence the proceeding. So while filing the originating process, they had also sought the court's leave that the exceptional originating process that they have sought to commence the proceeding through may be deemed to be appropriate by the court. Now, that question was to be settled by Her Honor Justice Forbes. It was not settled when the first set of hearings was conducted on 20 and the 21st of October. Until the court gives the LSB leave.
Is this leave to dispense with requirements?
That's right.
I don't have the rules in front of me, but the requirements are 5.03(1). Are they the requirements to file an appearance?
It's not so much an appearance, Your Honor. It's the commencement of the proceeding, proceedings that are contested and are.
So what's the problem with them commencing a proceeding?
The rules of the court normally require litigants to commence proceedings through a written summons. They have not commenced through a written summons. What they've done is essentially relied on an originating process that they need the court's leave to rely on in order for the process to be regular. The court must find that there was a proper basis for them to have done that. It's an expedited path that they've taken, but it's a path that needs to be ultimately deemed by the court.
So just take me to the rules. The passage in the rules. Can I say, Mr. Kuksal, is there any reason why you didn't put this in a submission?
Yes, Your Honor, I was getting to that.
What is the reason?
We were inundated with last-minute hearings that were organized in other proceedings.
Mr. Kuksal, the orders I made were dated the 28th of November, and you had until the 31st of January.
In relation to the costs, yes. But Your Honor.
It's 2 months.
Yes, Your Honor, in the last.
When did this argument occur to you? That you want to present now?
We've been aware of this argument since Justice Forbes.
All right, so I ask again, why has it not been put in a submission, in accordance with the orders, and filed so that I've had a look at it and Ms. Norton's had the opportunity to prepare for it?
Because, Your Honor, firstly the onus was on them.
No.
To follow the, No.
It's a different question. I'm asking you a procedural question now, why are you raising this argument that I've not thought about because, and Ms. Norton has no reason to expect is going to be argued this morning?
Okay, Your Honor, if I could get a few minutes to address that question.
No, yes, but I want you to answer
I am genuinely trying to answer that question.
All right.
Firstly, I think it's not fair to say that we would have expected this court not to be familiar with what has happened in this proceeding or VLSB to be not familiar with what has happened in this proceeding. We think that VLSB has in fact acted dishonestly in trying to perhaps opportunistically exploit. In the event that we were not perfectly ready to raise the issue, they would have exploited the opportunity and gotten by without complying with the requirements. They are a model litigant. It is in the wording of the regulatory requirements that they do not conduct proceedings in the manner in which they have conducted them. The second issue, which I think is more pertinent to what Your Honor would like to hear, is that in the last 2 months, I've had around 5 criminal proceedings were drawn against me. All of these were brought on at short notice, and there were a number of interlocutory applications that I had to make in the magistrate's court in relation to the prosecutors that had improperly commenced and maintained those proceedings. So we had far more work than we could deal with, in part because of issues with the legal representation that VLSB has caused, and their role was central in the improper maintenance of those proceedings, which were ultimately withdrawn for lack of prospect of success, and they have ultimately yielded a lot of evidence against VLSB. So it was not the only thing we wanted to say in relation to the submissions that we had to put to the court, and that's why it wasn't just as simple as putting half a page of submissions, because then it would be reasonable for the court and for VLSB to think that we didn't have more to say in relation to.
So you're saying you ran out of time to put?
We did not have time.
2 months wasn't enough?
Your Honor, 5 criminal proceedings.
All right.
5 criminal proceedings were drawn before trial, and there's hundreds of pages of disclosure material that's been discovered against VLSB.
Look, I understand. What you say is, you did not. Your submission is that you, or your position, you're saying to me, is that you didn't have time to raise this issue before this morning.
No, Your Honor, and that's what we wanted to put into.
All right, well, just tell me in summary.
Not before this morning, actually. We wanted to put evidence in, we sought leave.
Evidence of, but this is a legal argument.
No, about why we were late. We wanted to put evidence about why we were late and then file submissions.
So you had time to prepare. You proposed to prepare affidavits.
We have prepared affidavits.
So you've prepared affidavits saying why you couldn't put material in.
Yeah.
As an alternative to putting material in?
No, we also prepared material.
All right, well, have you got a written submission?
We have written submissions about the impropriety of VLSB in terms of.
Well, just take me through it. Tell me what the, take me to the form and tell me what the, at a high level, what is it that makes the proceeding defectively initiated?
Okay, so, Your Honor, does the court have access to the?
So then I should just get on the transcript that whilst you were talking, Ms. Zhu entered the court, and Ms. Zhu, you're here, appearing for yourself?
Yes, Your Honor.
Thank you.
Sorry for late.
And it was, Mr. Ansell is late on my account. He would have been here before time, but it was.
All right, so, Mr. Kuksal, just explain to me, in summary argument, why you say the proceeding was technically deficient, or is defective.
So, Your Honor, does the court have access to the document that was filed, the originating process that was filed by the plaintiff on the 7th of October?
Yes, I can bring up the original originating motion. Yes.
And just connecting to the internet. So when the court has the document?
No, I have it.
Okay, great, thank you. Now, Your Honor, if you go to the Supreme Court Civil Procedure Rules.
Yes, I've got those up too. Now, Ms. Norton, are you able to access the rules whilst you're there, to follow the argument?
Yes, thank you, Your Honor.
All right, so, Your Honor, the compliance with the court rules is dealt with by Order 4 of the Supreme Court Civil Procedure Rules. How a proceeding is commenced is 4.01, it's commenced under the Act, and so on and so forth.
Yes.
Now, 4.04, when writ is required, except as provided by Rules 1.12, 4.05, and 4.06 and Order 58, every proceeding shall be commenced by writ.
Yes.
4.05, when originating motion required, a proceeding shall be commenced by originating motion.
Let me just bring up, I see. Yes, yes.
So 4.04 is the operative rule, and I note we can rely on the transcript of the hearings in these proceedings as the record of the proceeding without actually.
Yes, so
during the hearings on 20 and the 21st of October, one of the preliminary issues that had been raised before Her Honor Justice Forbes.
No, just tell me the argument.
So 4.04 is how proceedings are commenced.
Where there's no defendant, where an application is authorized to be made to the court.
So that's 4.05, Your Honor. I'm talking about 4.04.
Yes, no, I've seen that, yes, and then it says it should be a writ, unless 4.05 or 4.06 apply.
That's right. Now, 4.05, a proceeding shall be commenced by originating motion, which is how they've commenced it.
Yes.
Where there is no defendant.
Yes.
Obviously that's not the case.
Yes.
Whereby or under any act an application is authorized to be made to the court. That's not the case.
Well, the originating motion says, pursuant to S 447, 5, of Schedule 1 to the Legal Profession Uniform Act.
Yes, that doesn't, so what they're talking about, Your Honor.
Yes.
Is that there are certain ACTS, like, for instance, the VCAT Act will say that an appeal of a decision of a VCAT member.
Yes.
Is to be commenced in the form of an originating motion, blah, blah, blah.
Yes.
447, the section that they're relying on of the uniform law says nothing about that.
What does it say?
It says nothing about the originating.
What does it say?
Okay,
Does it say an application may be made to the court?
That's right.
All right.
But it doesn't say anything about the originating process.
Okay, so S 447, I don't have it in.
So 447, I have it in front of me now.
Yes.
It says, injunctions to restrain contraventions of law or uniform rules. This section applies if a person has contravened, is contravening or is likely to contravene this law or the uniform rules. The designated local regulatory authority may apply to the Supreme Court for an injunction.
Okay.
On an application under sub S2, the Supreme Court may grant an injunction.
Okay.
It says nothing about the originating process.
Okay, I accept that then. But why does that not engage 4.05, 1b?
Because
that is an act that is saying you can apply to the court.
Your Honor, this goes to.
Look, can I say, I accept that I've always got the discretion to order that pleadings be filed or something like that, however the matter is commenced. Anyway, Your
No, Your Honor, if I may just complete what I have to say. Your Honor has the, so there are other rules in the civil procedure rules, the rules that we are referring to, which say that irregularity in the originating process is not in itself a fatal defect. So we're not saying that this is the end of the road for them necessarily. Your Honor is above the rules in the sense that Your Honor is a judge of the court.
Yes.
And judges can override the rules, suspend them, come up with a different process. Again, we're not saying that that is not possible in this case. What we are saying is that 4.05 specifically envisions a provision of the other act that sets out a process and says that an originating motion,
all right,
is the form of originating process that ought to be filed in the proceeding. Now, I've given Your Honor an example of an act that would be of that kind. So if Your Honor were to perhaps look at, I think, S148 of the VCAT Act.
That's the appeal, isn't it?
That's right.
The appeal to the court. All right.
So what?
And what does S148 of the VCAT Act say?
So section, a party to a proceeding may appeal on a question of law.
Yes.
From an order of a tribunal. So originating motions are appropriate on questions of law.
All right, but it doesn't. Am I right in my memory that that section of the VCAT Act doesn't say the application is to be brought?
No, because there's a separate rule in the court rules.
Okay.
That says that S148 is through originating motion. But the distinctive factor, Your Honor, here is that originating motions are appropriate where there aren't extensive differences about the facts of the matter and the question is one of law. The written statement of claim is the perfected method for resolving disputes of fact.
Would you be asking me to make an order that they file the statement of claim?
No, Your Honor, we would say that Your Honor should not find that this proceeding should be in this court in the first place.
All right, so I understand your argument is 4.05(1)(b) is not engaged.
It is not engaged, and Your Honor, this is the other part, they know about this because this matter was raised before Her Honor Justice Forbes.
All right, I understand that. What, is that the other? Is that the only argument?
No, that's the second argument is the more important argument because…
Well, which is that one?
It's that they have made an application before Justice Forbes.
No, I'm interested about your technical legal argument that…
No, so, if I may complete.
Just let me say, I should say it for the transcript that Mr. Ansell has now appeared in court.
Yes, and as I clarified, Mr. Ansell was…
All right.
Collecting me from my residence and Mr. Ansell's…
Right.
Late on my account.
My apologies, Your Honor.
It's all right.
Your Honor.
So 4.05(1)(b) doesn't apply there for the proceeding as being defectively commenced?
Not just that, Your Honor. Not just that.
Yes.
And this is very important, if I could get a few minutes to address this. We have made the exact argument before Justice Forbes.
All right.
Justice Forbes had not found that.
It's a live issue.
Yes.
You're saying it hasn't been.
And what Her Honor had said was she needs to determine whether or not these proceedings should be allowed.
Okay.
Yet or not, because, Your Honor, one of the other arguments that was raised is that even with the originating motion they need an affidavit. The affidavit of Mr. Ben Davidson is, we say, a product of perjury. They say it is innocently misleading. But it is an admitted fact that it contains inaccurate information which, Your Honor, the inaccurate information, one of the pieces of inaccurate information is whether or not I'm a shareholder of the firm.
Right, so it's invalidly commenced because the is in the affidavit.
The affidavit is a fraudulent document.
Okay.
And since that argument was raised, Mr. Ben Davidson has stopped attending court.
Right.
Because he's on notice that I will require him for cross-examination.
All right, so…
In fact, we've done an affidavit about that issue. It's been lodged in this proceeding.
Yes.
That affidavit, previously.
So why does this mean you shouldn't pay costs to the court?
Because there is no proceeding right now. The court has to first decide whether there is a proceeding and also, Your Honor, if so, ultimately, the recusal application in relation to which the costs are being considered if that application was brought upon us frivolously because we were forced to be in a proceeding which, in fact, was invalid and the court had explicitly reserved judgment about its validity. How can the court award costs in relation to a proceeding?
Yes.
About which it has reserved judgment in relation to its validity?
The difference between the proceeding by originating motion and a proceeding by writ is, in substance, whether or not there's a question of
fact,
of pleading. So procedurally, the difference is in a proceeding commenced by writ pleadings will be ordered or pleadings are required. And in a proceeding commenced by originating motion, there aren't pleadings normally.
So, Your Honor, if Your Honor is…
But if that's…
Looking at the practical aspect of it.
Yes.
It's that they're saying there is complete agreement about the facts.
Sorry, what?
Which there is not.
No, I don't know if every originating motion necessarily requires that.
No,
But are you saying that you want pleadings?
we're saying that the document is scandalous, the proceeding should be dismissed.
Okay, yes. But do you say that? Do you say is it your position, centrally, that if they want to bring an application for the injunction, they have to do so by a system that allows for pleadings? Provides for pleadings?
Your Honor, that we're not taking a general
You don't.
philosophical position about it. We're talking about this specific instance. We're saying that in this proceeding we have evidence that there has been extensive misleading of the court. We say that they have deliberately refused to provide any information to the court.
You don't.
We're requesting an order that the court find that these proceedings are scandalous and they have been brought on as an abuse of the court process. Now, we brought physical evidentiary documents because the court hadn't given us leave to. This, Your Honor, is a very short excerpt of documents selected from thousands which have been discovered. They prove that the proceedings have been started as an abuse of the court process.
Right, but you're not requesting an order that they provide.
And this includes documents which Ms. Norton was willing to provide to the court previously on the 5th of December, but her instructor had changed their mind, for lack of a better phrase. He's also not in court because we have put them in on notice.
So you've got a folder there?
Yes, of 389 pages. We've numbered them already.
And what does that folder show? Well, what are those documents in summary?
Okay.
Just in summary.
Yep.
Are they letters?
So.
Are they reports? Are they court cases?
No. So these are.
Transcripts? What are they?
No, they're not transcripts. So, Your Honor, if I could get 5 minutes to quickly summarize the evidence that we collected. What has happened is that the LSB has been trying to speak with everybody who had some issue with me over the last, since 2021. Not because of a particular act of investigation, but because I had made it clear that I was going to sue Mr. Howard Bowles, who is the person in charge of investigations at the LSBC. Mr. Howard Bowles is very close with the producers of A Current Affair, and the whole situation started when A Current Affair was broadcasting a segment about one of my businesses. Mr. Howard Bowles made a comment. At that point in time, I saw that as a great opportunity to start the business that I wanted to start in relation to holding administrative bodies to account, so we conducted a lot of research about all the laws that have been broken by Mr. Bowles by making that comment. Subsequently, a lawyer that I fired went and told Mr. Bowles about all the preparation. Now, we had evidence of all of that, clear evidence of all of that which has been discovered in other proceedings. Mr. Bowles thereafter tried every opportunity to speak with anybody he could speak with about collecting complaints against me. He proactively contacted Victoria Police members to collect files that Victoria Police was maintaining against me. Victoria Police was not interested in providing those files because it's unlawful. They sought some sort of certification from.
Yes.
So, Your Honor, there's the Public Administration Act, which prevents government bodies from communicating with each other unless it is for a prescribed purpose. Victoria Police sought certification from the LSB that such a purpose existed. At that point, Mr. Matthew Anstey, the Director of Investigations, provided Victoria Police with such a certificate. Since then, the LSB has been through a couple of police officers that were cooperating, speaking with every police officer that has been involved in any matter, proactively requesting interviews, so on and so forth. They've also done that with any customer of any of my businesses who had some issue with the manner in which they had received the service. Not legal service, any service. In fact, the LSB authorized lay citizens to be points of contact to then further create Facebook groups to encourage people to make complaints to the LSB. I was never provided any information about any of these complaints. The LSB opened and shut these complaints down because they had no lawful purview. At some point in May 2021, the LSB wrote to the Magistrates Court of Victoria and to the County Court of Victoria to advise them that all proceedings commenced by me or an entity controlled by me should be stayed indefinitely because they had reason to believe that the lawyers who were certifying the 4A and 4B certificates under the Civil Procedure Act had not been acting completely independently. So this is Civil Procedure Act that we're going under. The courts officially, obviously, asked them to get lost, but obviously it prejudiced a number of magistrates who had access to these letters in the cases. I came to know about this because, again, the information was discovered in proceedings. I confronted the LSB about it. I was told that at some point I would be given all the information. That point has not occurred yet. I was told that in May 2021, the statute of limitations for the offense in relation to which they were investigating me has expired long since. In fact, they have published in their annual report, last year's annual report, that they have closed the investigation about me. The relevant part of the annual report is also here. So they kept collecting these hate mails against me and kept posting defamatory content against me online, which further generated hate mail against me. Then, essentially, this encouraged Victoria police officials to basically bring on proceedings against me without proper cause. The LSB and Victoria Police got into an unlawful conspiracy to undermine my legal representation right at the point where the bulk of the trials were scheduled. So they systematically identified when it would be most prejudicial to me to take out my legal representation. And Ms., that's where Ems and Naz fell in perfectly, in the sense that because the firm did not have any trust accounts and because all the clients were either entities controlled by me or I, the LSB had no purview to investigate the firm. Investigations relevantly can only be commenced where there is a consumer complaint, where there's a referral by a judicial authority, there was none, or where there's questions of improper dealing with trust accounts. Ms. Naz, again, there's extensive evidence about the manner in which the issues with Ms. Naz progressed, but co-conspirator of Ms. Naz, on the 21st of July, wrote to the LSB and that email, again, has been discovered in another proceeding. That person was an employee of the firm. They were a lawyer, and what they said to the firm was that I was effectively running a sweatshop and the LSB had to break into the, brick walls with no ventilation to rescue some, trafficked lawyers who had been trapped inside the firm's premises. With that as the basis, also, the other issue that had been taking place in all of this was that the LSB was getting private law firms to communicate with the court and to communicate with my lawyers, pressuring them to give evidence against me. They have, under threat of penalty, interviewed lawyers that had acted for me and basically breached privilege in a number of ways. They have pressured them to give false evidence against me. We have evidence of that as well. Mr. Ansell was.
Do you want me to make on this costs application, do you want me to make a final conclusion that the proceeding is the result of a conspiracy?
No, I'm saying you can't make a determination in relation to the costs application until you determine whether or not the proceeding was validly commenced.
Yes. And you're saying it's invalidly commenced because of the rule you identified and because it's been brought as a part of a conspiracy and with bad faith?
No, there's two, that's one of the grounds.
Yes, well, that's two of them, isn't it? One is that it's not authorized by the rules.
That's right. Well, there's two subsets of that. One is that the originating motion was this writ.
Yes.
The second is, even if originating motion, they still need a valid affidavit.
Okay, yes.
And because the affidavit itself, it's not.
Okay, no, I just understand it. So that's one argument.
Your Honor, the affidavit is inadmissible according to the Evidence Act on a number of grounds. And we have all of those grounds ready.
Right.
It's full of hearsay evidence.
So I understand that's one argument. There's another argument that the proceeding is a product of an unlawful conspiracy between.
Absolutely.
Yes.
And we have all the documentary evidence.
On that point, are you asking me to make a finding? Is your position that I should make a finding on this application, that there's an unlawful conspiracy? Or is your position that I should not decide this application until the question about whether there's been an unlawful conspiracy has been resolved?
I think they're both the same thing. It's the same way of saying the same thing.
No, it's not. One is you saying to me you've got an argument that there's an unlawful conspiracy.
And you should decide that first. You have to determine that first. The second thing is the same thing as well.
Have to.
And so I'm not saying that, Your Honor, just take my word for it. I'm saying that Your Honor look at the evidence, give them an opportunity to file evidence and me to cross-examine them about that evidence and then make a decision. And then, secondly, Your Honor, we're not actually asking the court to deviate from any course of action because this is where things were. This is where things had been left by Justice Forbes. Now, if I could just complete the narrative, I was more than halfway through.
Yes.
So the action that was commenced was in relation to purported breaches of the WorkSafe Act and the, WorkSafe Act only. WorkSafe conducted its own investigation, did not find against us. In fact, dismissed all the complaints that were made against us. They even questioned Mr. Rapke about whether or not he wanted to give evidence about that. And told him, so, he was very happy to give evidence until they told him that any evidence he gives will be discovered to us. And then he said, well, he had no business giving any evidence because he was simply appointed in relation to the practice and not the firm that deals with the human resources. So the LSB gave evidence in a VCAT proceeding that Mr. Ansell started to challenge the appointment of an external manager to his personal practice. The evidence said that they were concerned about proceedings being commenced vexatiously. Completely, it was a completely fabricated narrative which they have themselves backed away from since then. The annual report that they published says that the practice was shut down because there was a high turnover at the law practice, literally. It says there was a high turnover. And consumers, it does not specify what consumers. So it has conflated complaints that consumers of a related entity which provided logistical services had made at the invitation of the LSB to legitimize that as complaints by legal services consumers. Those are the reasons that are given. In the affidavit that was filed in the week at proceeding, those were early days and they were still hoping, at that time, that they would find some stuff against me. At that time, and we have a copy of that affidavit here as well, it specifically points out that they're concerned that too many proceedings have been started and a lot of it may be vexatious. Mr. Rapke contacted every court and tribunal in the country and made a list of some 80-something proceedings that he could find that can be traced back to me since I arrived in this country. They predated the incorporation of the entity that practices law, of which he was purportedly the external manager. That was used in the VCAT proceeding to argue that there was evidence that the firm will commence proceedings vexatiously. Now, Your Honor, on the day the documents were seized, Channel 9, who we were suing for defamation, was given full access to all the files. They recorded the content of the files. And what is very important, Your Honor, an email was sent on behalf of Mr. Howard Bowles, the person who's been responsible for all of the appointments, to Mr. Oni, a senior constable who is an informant in a proceeding against me, the only criminal proceeding besides any regulatory action. That's still afoot against me. 8 criminal proceedings have been dismissed against me directly. I think 3 more against associates. So 11 criminal proceedings have been dismissed against me over the last 2-3 years. 1 remains. The senior constable in that proceeding was sent an email the day of Mr. Rapke's appointment to inform him that if he needed access to any file about me or any of my associates, he simply needs to contact Mr. Howard Bowles because he has seized all the files of the practice. Now, Mr. Oni has fabricated evidence. The magistrate's court has judicially found that Mr. Oni has provided the court with multiple affidavits which are factually inaccurate. And they're inaccurate about the sort of things that one cannot reasonably be wrong about. Some of the inaccuracies, Your Honor, are that I have an extensive criminal record. I have none. This was said to the magistrate to whom an application was made for a search warrant to my premises. That magistrate was told that I am a seasoned criminal with an extensive criminal record. Now, that the LSB had been continuously, in concert with that particular senior constable and that particular senior constable against whom, so, the other thing that happened was on the day the search warrant was executed, my place was riddled with surveillance devices. In fact, when I came up to answer the door, I had a cell phone on me which was on recording. The people who arrested me, by the way, Your Honor, the notes, the Victoria Police internal notes that have been obtained, there.
Mr. Kuksal, you're identifying all the arguments you've got about why the proceeding is an abusive process.
Your Honor, I'm finishing the narrative so Your Honor has a complete picture. So the phone was on recording, it was seized and stupidly carried around by the person in charge of the unlawful raid at my premises on their person the whole day. It captured incredible incriminating evidence against that person and some others. That person has been on medical leave for psychiatric purposes, which is how they're, up until now, anyway. I'm not going to get into more details, but that is the basis on which they're evading cross-examination. That person basically was telling police officers that they have to be very careful about when they take photographic evidence because I will have every forensic stone turned to prove that they've done the wrong thing. By the way, they got caught on the metadata of the photographs as well. Now, the LSB received complaints against Mr. Ansell for his advocacy of me in that proceeding. The plan was to basically say I'm a very scary person, the witnesses will be too scared of giving evidence if it was out, and therefore I should be locked in jail. Your Honor, the other thing that they had done was, I have 2 entities. One is called Avant-Garde Ventures Pty Limited, of which I was the director, the other one, Avant-Garde Logistics Solutions. They presented the ASIC summary of the first one to say that I was the director of the second one. That's how they got the search warrant, because the search warrant was in relation to the second thing. I figured it out during the police interview. Mr. Ansell brought it to the magistrate's attention. The magistrate said they have nothing on me. So she would not authorize that I'd be locked up for an indefinite time. Since then, there were a number of complaints made against Mr. Ansell to the LSB about the fact that he was starting a paper war against the police by providing all the evidence against the corrupt police officers. And the LSB has been coaching Oni about what to say, and they have literally given him a script to provide to prosecutors. And the script said that Mr. Ansell, who purports to be the legal representative in the case, doesn't really have a lot of criminal background and may not be drafting documents itself. So the prosecutors are not to take any submissions made by him at face value. The Legal Services Board is investigating him and the firm. He did not know that he was being investigated at that time. Neither did I. Then there was an associate of Mr. Bowles who was attending every hearing in which I've participated judiciously. They were on time every time when I was not. And that's how the LSB has been essentially looking for an opportunity to prejudice the proceedings that I'm commencing that I foreshadowed against Mr. Bowles. Now, in a lot of these cases, Your Honor, in the magistrate's court, they had a very straightforward line that I'm issuing subpoenas vexatiously, I'm trying to essentially disrupt LSB's investigation of me, blah blah blah. And for the first I think 10-15 times, they succeeded. Ultimately, I did not give up. On one occasion, I was locked up for potential contempt of court because I repeated these applications over and over again until some magistrates finally saw that there was a conspiracy. A judicial determination has been made in relation to LSB's conspiracy with Victoria Police in the only proceeding, and it's been found that that is an arguable ground for me to raise for the dismissal of that proceeding that the LSBC has spurred on Victoria Police. Your Honor, the best part is that Victoria Police knew that they did not have jurisdiction to commence the proceeding in the first place because under the consumer law, a private person cannot be charged with a criminal offence in relation to consumer offences by Victoria Police directly. Consumer Affairs Victoria, or the Director of the Consumer Affairs Victoria, is the entity that has to investigate the matter. They have previously written to Consumer Affairs Victoria and told them about their understanding of the law in that respect. It was only after the LSB involvement that the police decided to go against jurisdictional restraints. Now, Your Honor, the LSB has simultaneously used MZNAS to pass documents between Victoria Police and itself so they can evade disclosure processes. The email exchange between Ms. Anaz and Mr. Oni where this is discussed was also discovered, ironically. There is concrete evidence in the proceeding, which we have in documentary form right now, that the LSB has counselled MZNAS to give fraudulently dishonest statements against me, which actually contradict the statements that she had given to the LSB previously. And then, for the police to pass, so MZNAS gave those statements to the police, whilst asking the police to pass on those statements to the LSB, so the LSB would then have them through formal channels. There's an email exchange between her and Mr. Oni that clarifies that. So there's further evidence. The person who arrested me on the day that Ms. Anaz's parents made the complaint against me was a person who had been involved in the Oni proceeding. So the person that showed up, the person in charge on the 20th of July 2022, Mr. Andy Sapir, was a person who had been involved in the Oni investigation, who had extensive documentary exchanges about the firm's involvement, that's People Shop Pty Limited's involvement in foreshadowing defamation proceedings against people who were making fraudulent allegations against me. And he recruited MZNAS. It took the police 2.5 hours to have MZNAS move from the place where she was staying. I've been nothing but good to her, to making mildly offensive statements against me, and then, from there on, it went downhill.
Mr. Kuksal, you've got to move.
This is the conclusion, Your Honor.
All right, good.
So what I'm saying is, all of this evidence is before the court right now. We can provide the binder, and we have digital copies to circulate. This is not stuff that we are making up or we are suggesting can be discovered. These are email exchanges between the relevant parties. And the other part, Your Honor, Mr. Rapke, on the 6th of September, filed a ceasing to act certificate in the Channel 9 matter, in the defamation matter, in this court. The address that he put on that ceasing to act certificate, for further service of documents only, was off a little bit in the house number. It said 26 Waiora Parade. Ms. Anaz had, not long before that, texted her mother with the same address for my residence. All the information that the LSB had came from Ms. Anaz, and that was used to essentially destroy Mr. Ansell's career, the careers of a number of other people that have been adversely affected and caused all sorts of prejudices to me. There is no evidence that they have filed about any unlawful activity or any contraventions of the uniform law in this proceeding. All that is suggested is that the firm is atypical or unconventional in the manner in which it is set up or it conducts its business, and it's not something that they're very thrilled about.
Yes.
And for that reason they have sought an injunction, obtained it improperly, and they want to make it a permanent injunction.
Yes.
That's all that there is to it. They have not charged me with anything. The statute of limitations has passed for anything they could have charged with me with. They have said as much in the email exchanges to the various parties. Since they seized every document from the file from the firm, I was a client of the firm. I could have taken the files back. They cannot seize the client's files against the client's consent. They can only seize them from the firm. If the client wanted the files back, they can't take the files and keep them. That's what they've done, right before criminal files.
Yes.
Now in those circumstances they've still not been able to find a single thing to charge me with since the 22nd of August 2022. Over a year, they've not found anything to charge Mr. Ansell with. And forget about charging, they're not even suggesting that there's an active investigation going on. All that they're saying is that this firm is being run in a way that's unconventional and possibly prejudicial to Mr. Bowles' personal interests, and therefore he would prefer that did not exist. So that's essentially, Your Honor, what the submission is. Now one final thing, a different thing that we want to raise is that at the last hearing what Your Honor had specifically said was that the LSB was to circulate a proposed amended originating motion. We would get an opportunity to address it.
Yes, I just want to deal with the first bit first. The costs.
Well, there is no costs, Your Honor.
No, but the bit that you've been addressing me with.
What I'm saying is that Your Honor cannot hear the cost application right now or decide it right now because Justice Forbes had said that the first issue that needs to be resolved.
No, I understand. That's the argument you've been presenting. I thought you were moving on to a different point.
No, I'm saying that the originating motion also, while it's a very brief point.
Yes.
They have got it improperly ceased. We don't have consensus between the defendants about whether or not this is attributable to Your Honor. It's Ms. Zhu's position that it's not attributable to Your Honor and it's...
I don't understand. What?
Your Honor said at the last hearing.
They should circulate a proposed amended.
Yes, and that Your Honor would not let them. Just file.
That's right.
That's what they did. It's sealed.
No, but that's the summons. That's seeking leave to amend the originating motion.
No, but what Your Honor had said was that before they filed that they had to show a proposed originating motion.
Yes, I understand that. So the summons they've filed has not perhaps got quite the right, because the summons is seeking an order allowing an amendment of the originating motion, but they have circulated.
No, and Your Honor had specifically said that Your Honor would not let them file that before showing what the proposed amended originating motion was.
I thought I had said I wouldn't let them file an amended originating motion without circulating it.
No, it was the summons. It was our understanding it was the summons. Because what Your Honor had said was that I'm not going to give you blanket authority to seek leave to file whatever. You have to first show what the amended, that's what Your Honor's position has been with us.
No, I thought what I said to them was, I'm not going to give you leave today to amend. You've got to make an application to amend so that everybody knows what the amendments are that you're talking about.
That's right.
So we're saying the same thing.
But they never, so.
No, what they've done is they've filed the summons setting out the changes they want to make to the originating motion. Yes, so they haven't typed up a version of the originating motion with those amendments in the summons on the proposed originating motion.
No, they haven't, and also, it's very confusing, the manner in which they've done the thing.
All right.
And again, Your Honor, so that application, we say, should not be discussed until the proceedings are fixed in terms of whether or not they even exist or should be allowed to continue, where it's seeking to have the injunction and the proceedings dismissed because this is a court of equity. Injunctions, where they are without basis, are instruments through which the court oppresses parties against their lawful interests. This court is unlawfully keeping me from utilizing my intellectual property without basis. It's preventing Mr. Ansell. The LSB has been threatening Mr. Ansell for confiscation of his house, everything that he owns, because he is not giving in to their intimidation tactics. During his examination, Your Honor, he was told that the LSB has evidence.
Mr. Ansell might want to speak for himself.
Well, Your Honor, our interests are, we are one in this proceeding. So, Mr. Ansell, and he will.
But what are you directing it at? Have you said what you want to say on the question of costs? Have you now moved into...
I think Your Honor is taking a very narrow view of the issue. What I'm saying is...
No, I understand one of your arguments about costs is that the whole proceeding is an abuse, and no cost should be ordered in a proceeding which is potentially going to be determined to be an abusive process.
Not just that, but what I'm saying is that the court should not continue injunction.
And you say the question of the abusive process has to be determined before any further orders are made.
Not just that, but I'm saying this proceeding should not be allowed to continue.
Okay, well, if I found it was an abusive process, I'd...
But we don't want you to find that, you know, several weeks.
Okay, I think I do understand you're saying that that's the main issue that has to be determined.
That's right, and what we're saying is that right now the court has made an improper order.
Yes,
It was an interlocutory order. Your Honor must hear us about why it was improper.
Mr. Kuksal, what order are you saying is improper?
The temporary injunction by Justice Forbes.
Okay, I'm not going to hear that today.
Why not, Your Honor?
Because, Mr. Kuksal, we're here to deal with the costs application and the application to amend, and you had.
Well, Your Honor, there is no cost.
There is a cost application. Now you say I should look at it in a particular way.
No, what I'm saying is Her Honor Justice Forbes had set a schedule.
All right,
This new schedule contradicts the old schedule.
Alright, is there anything? If I do go on to this, I'm going to have to reflect on things for a period of time. If I do go on to decide I'm going to determine costs, is there anything else you want to weigh?
We would say that it would be a highly improper.
Okay, but anything beyond that which you've already said?
I would just be using synonyms, but no.
Alright, thanks, Mr. Kuksal. And on the application to amend, you've presented the argument that I should not allow the amendment. First of all, you say the proceeding is improper.
I'm saying you first need to determine whether or not there's a proceeding, because not only.
And then you say if I do, and then you say that there's a technical deficiency in the way they've brought the application because they haven't.
Two bases for that.
But just in terms of the application to amend.
Yes.
They haven't circulated a proposed amended originating motion.
Okay, that, and also, they haven't first carried through their application that the court regularized these proceedings.
Okay.
How can they amend something that hasn't even been regularized in the first instance? That's, again, Your Honor.
Thanks, Mr. Kuksal.
We haven't coordinated our response in relation to this matter. A lot of the questions were asked by Your Honor, so I wasn't.
No, I appreciate that.
Thank you.
Who's the first defendant?
I am the first defendant.
I meant who's the next. Mr. Ansell is Mr. Ansell. Anything to add?
Yes, Your Honor. Thank you.
First of all, do you adopt what Mr. Kuksal said?
Yes, Your Honor. In relation to his arguments in regards to the process.
Yes.
Certainly concur with all the statements and arguments that he's put to the court today in relation to those matters. I can certainly further give the court additional evidence in relation to matters that we say were committed by the LSB, and certainly in my position, I can illuminate the court further on those matters if you.
It's more are there any submissions you want to make that Mr. Kuksal didn't make?
No, Your Honor.
Thanks, Mr. Ansell. Ms. Zhu, do you adopt what Mr. Kuksal has said?
Yes.
Are there any submissions you wish to make in addition to what Mr. Kuksal said?
Yes.
Yes. What are those?
So can I take the sequence, like can I address the summons that they're bringing in first?
The proposed amendment?
Yes.
Yes. What would you like me to look at?
So I will address that first. And then the cost only for a short time.
All right.
It's quite the same as Mr. Kuksal, but I think he's used some different wording. But my understanding was that from Your Honor's oral directions on the 28th of November 23, basically what's said is that, can I have Your Honor go to the transcripts of the 28th of November 23?
Give me a moment to find that. I will be able to find that.
Thank you. It's P41.
I've just got to pop in my order as well, somewhere, just looking at what the order itself said. The plaintiff is to file to the parties a copy of any proposed amendment to its summons or originating motion forthwith, an application of amended summons or originating motion. It really should be an application to amend the originating motions made by summons. Yes, so I've got the transcript. What page did you want me to go to?
41.
Yes, I've got that.
Yes, so on that day Mr. Armour appeared for the plaintiff, and he had told the court that they want to file an amended summons, and then I raised it with the court. I said if they need to file any amended documents there needs to be amended originating motion, then…
Did you? That was well picked up. Where did you say that? I didn't mean to sound patronizing when I said that. It was well picked up that what they were really trying to do was to amend the originating motion.
So they want to amend the summons, but I said that they can't just amend the summons. If they really need to amend them, they need to amend the originating motion.
Where did you say that?
I will find it and let the court know, but…
I think it was said in Chinese, Your Honor.
But on P41 this is the exchange. So Mr. Armour said, in light of that it may suit to make the directions.
What line are you? Line 19. Yes.
The direction that the plaintiff file and serve an amended summons, if any, to be filed and served, as well as supporting affidavit material by the 8th of December, and then Your Honor said no, but what I'm saying is I'm not going to give you leave to file an amended summons. I'm going to say you've got to bring an application to amend your summons.
So I probably have contributed to the mistake. I should have been saying, I'm not going to. What I ought to have said is that, I'm not going to give you leave to file an amended originating motion. I'm going to say you've got to bring an application to amend your originating motion.
But my submission is, in any event, they did not follow Your Honor's order or Your Honor's oral directions, because on the 15th of December 23 I was only expecting a summons filed to the court. That's like a one-liner that we be given leave to file amended originating motion or amended summons.
Yes.
That should be the application they file, and that's what Your Honor's Order 7 says.
Yes. And if we look at the summons that was filed, it says, you were summoned to attend before the court on the hearing of an application by the plaintiff for an order in the originating motion, amended as follows. And then it marks out how it wants to amend the originating motion, doesn't it?
Yes, but they will say that this is our application to amend the summons.
Okay.
They need to. So first of all, they did not follow the first order that is proposed amended summons or amended originating motion forthwith. Not that I have any problems of parties being late, I don't criticize them for that, but I will use that for another argument. But the point is that they need to make an application to amend the document. And the document they filed was the court has lodged that application. And I will say that,
Your Honor, I found the line which Ms. Zhu was earlier referring to. It's line 11 on P32. Actually all of P32 line 1, she says.
Yes, they should amend the originating motion. Yes.
Amend the summons, yes. And there's discussion before that as well on P31 and 27, so 27, 31, 32.
All right. Well, I can see that line 12 is where Ms. Zhu clearly says they should really amend the originating motion.
That's right.
All right.
And, Your Honor.
Thanks, I appreciate that. Yes, Ms. Zhu, so you're saying that they haven't circulated a copy of the proposed amendment?
forthwith, but I'm not worried about the time. But the issue is that the summons that they filed is not to seek an amendment. The summons that they filed is to ask for more orders from the court, to further restrain the defendants. And I say that is not what Your Honor asked them to do.
No, but isn't that what they were talking about having including in their amended originating motion?
No. So first they need to serve the proposed amended document, either summons or originating motion to the defendants.
I think I understand.
And then the summons that they filed on the 15th of December should be that the court grants them the amendments.
Yes, yes.
And they attach the thing and say this is what we want the court to.
I understand.
I think what she's saying is that.
Mr. Kuksal, let Ms. Zhu, she's an intelligent woman. Yes.
Your Honor, my English is...
Your English is perfectly adequate, Ms. Zhu. I've never ever had occasion to think you didn't understand me or that I didn't understand you.
She doesn't get sarcasm.
So what I'm saying is that they have presumed that the court, my submission, they've presumed that the court has already granted them the amendment, and then they filed an amended summons to seek more orders.
Thanks, Ms. Zhu.
Yes. That's what I want to say about their application today, and then I will just further add that this is an abuse of the process, because Your Honor had told them not to do that, because Mr. Armour had suggested that they would file an amended summons.
Yes.
So my submission is, in February 2023, the plaintiff, the Legal Services Board, should tell the court or put, either by way of correspondence or affidavit, in some form they have some responsibility in informing the court that the manager had ceased his appointment, or that he, or indicate to the court that they don't need the protection anymore.
Yes.
Because they've made that application before Your Honor rejected it, they still tried to do that, so that's an abusive process. And then I'll just also address the costs application. It won't be too long.
Yes.
So my argument is that, so now they have put that in evidence, that Mr. Rapke has ceased to be the manager of the firm. So my understanding is that Mr. Rapke has ceased his appointment in February 2023, so it's pretty much exactly 1 year before today. So it's been 1 year since he finished his appointment, and only until the 15th of December had the plaintiff put that in evidence to the court, by way of Mr. Ben Davidson's affidavit, and that was addressed in Miss Norton's written submission.
So he did. Were you unaware of the fact that he'd ceased to be a manager until
much later.
Until you were told by the board?
So my argument is that, so now they have put that in evidence, that Mr. Rapke has ceased to be the manager of the firm. So my understanding is that Mr. Rapke has ceased his appointment in February 2023, so it's pretty much exactly 1 year before today. So it's been 1 year since he finished his appointment, and only until the 15th of December had the plaintiff put that in evidence to the court, by way of Mr. Ben Davidson's affidavit, and that was addressed in Miss Norton's written submission.
Yes.
Okay.
Because I'll just ask Your Honor to open the originating motion document.
Yes.
So,
The original one that was filed?
there's only one. Yep.
Yes.
So it says that, so paragraph 2, it says that pursuant to, of the legal of the uniform law, an interim injunction restraining the defendants pending further order from obstructing Mr. Howard Rapke in his capacity as the manager. So this is paragraph 2.
Yes, I can see that.
And then paragraph 3 says that, a permanent injunction restraining the defendants from obstructing Mr. Howard Rapke in his capacity as manager of the law practice from exercising his function under the uniform law.
But the order that was actually made wasn't limited in that way, I notice. But anyway.
So my point is, the court has jurisdiction to make orders to restrain people from doing things, the court's jurisdiction is invoked by the plaintiff making a written application to put something in the written form and say here is what we want, and this is the basis for why we want the court to make an order.
All right.
That's the only basis that I can understand from reading this originating motion, and that's why the court has jurisdiction or has justification in why they have the power to restrain the defendant from doing things.
So, Your Honor.
No, Mr. Kuksal, just.
Yep.
Ms. Zhu's addressing me.
I just know that Mr. Kuksal may have some further...
No, but I want to hear what you've got to say.
Yes. So my submission is that we are forced to come to the court, because there is no need from the February 2023, there is no need for them to have that order anymore. There is no need for the interim injunction, or the permanent injunction, based on the current originating motion they filed with the court. And the court, both the court and the plaintiff, need to justify themselves in restraining us, in continuing the injunction or a restraining order. However little impact the court may think that it will give us doesn't matter, cause it is still a restraining order. While we have, news reports, articles published online, saying that we're under a restraining order because there is an implication that we are obstructing the manager, when the court has made no findings against us, and there's no justification for this order to continue to exist, and as the plaintiff, they have some responsibility, have some duty to the court to inform them that they no longer need that protection.
All right.
And that's why I say that first in August 2023, when the matter is first before Your Honor, I made an oral submission that we want to vary and then because of some reasons, we couldn't make it. But I will say that my submission is that we should not be the party bearing responsibilities to ask the court to vary the order. They should, or the court should justify themselves in maintaining that order. Because it is a power that's been put on us. So, and again, there's no justification for that anymore. So the plaintiff, after our August date, brought another direction hearing after the August date. They said to the court that they are ready. They said, we have material. We really want a permanent,
Yes.
We really want a permanent injunction against the defendants. That's what they said. They said, we've got the material, we're ready, everything is done, right? Like the court must believe them. That's why the court will say that yes, send the proposed summons forthwith.
All right.
That's why the court must, I will say that I submit that the court is of the impression that they're ready to issue us with all the material they have against us. But my submission is that they don't. They are not prepared. They don't have the material. They have no idea what they're asking. They don't know if they want to file summons or if they want to amend the originating motions. They haven't even put in affidavit that of some very important changes. So on the 3rd of November 23, we were brought to this court for a direction, but we were here for no good purpose. They brought that direction hearing, but they haven't really prepared anything to tell the court. They said that, we really want to have the permanent injunction, but they haven't got the material. I will say that they may have the argument that, because we have made a recusal application to the court, so they are stopped from making their application. I think that will be their argument, but then if that is the case, then on the 28th of November, when the court dismissed the recusal application, then they will have the material ready to go. But they did not do it forthwith. So that's why I say that, on the 3rd of November, we were unnecessarily brought to this court.
All right. Thanks, Ms. Zhu.
Sorry, just another 2 minutes. And then, so I said for the 3rd of November, it's really not we don't have to be here. We don't have to be before Your Honor and make a recusal application. The recusal application is, we thought we have to make that application because a lot of the information was not given to us. For example, the Your Honor Chamber's exchange with the police officer, and a lot of things. We were under the genuine impression that that is an application that had to be made. But if they were really ready with their application to progress with the matter, they would do that already. But they have not, and we were forced to attend this court in this proceeding when they have no justification, no movements, no action taken. And I want the court to really make a determination that is the court say that the defendant needs to take the responsibility to have the proceeding end because the manager is no longer the manager, or will the court say that it's the plaintiff's responsibility to maintain those orders? They need to justify why the order should continue.
All right.
So, and then for the 28th of November 23 cost, I will say that it's either that the court dismiss their summons today and order them to pay us costs for the 28th of November, or that day's order. That day's cost will be party's own cost because that day the court has dealt with a lot of different applications, including Mes de Gregorio. So it's really not that we have wasted any time.
All right.
Yes.
Thanks, Ms. Zhu. Now,
Your Honor, I did want to quickly raise a few issues.
Mr. Kuksal, you had an hour and a half.
Because Ms. Zhu has raised independent issues and now that she's raised them, Your Honor, had asked me specific questions. Ms. Zhu progressed the matter further.
What do you want to talk about? In what category of dispute do you want to address further submission?
In relation to the impropriety of LSBC about not keeping the court abreast of various matters.
No, I'm not interested in hearing from you more about that.
But I didn't address the court about that at all. Ms. Zhu has.
You had your opportunity, Mr. Kuksal.
But, Your Honor, you asked me very specific questions and you asked me to only address those questions.
No, I didn't. I asked you if you had any more to say, and you.
About those questions.
Mr. Kuksal.
Your Honor, that was my understanding.
What do you want to say? You just want to emphasize.
No.
That Mr. Rapke ceased to be a manager.
No, what I want to emphasize is that in AJH Lawyers v. Matheson Nominees Pty Limited and another 2015 VSCA 227, also in Batrani v. Forster 2015 VSC 230, this court compared the obligations of managers appointed under the uniform law and receivers as the same obligations that apply to prosecutors in criminal proceedings.
Yes.
And that they have an obligation of disclosure to the parties, and they have an obligation to the court to not use its compulsive processes oppressively. In those proceedings, it was found that the external interveners had fallen short of those matters and their applications were dismissed.
Right.
Your Honor, I also refer the court to Mullett v. Nixon. That's 2022 VSCA 174. That speaks about the disclosure obligations under S26 of the Civil Procedure Act pursuant to the overarching obligations.
Were you aware that Mr. Rapke had ceased to be a manager?
Were you aware that Mr. Rapke had ceased to be a manager?
So when, but before when?
We knew before December 2023, but they didn't tell us.
Okay.
Right after he ceased.
All right.
But, Your Honor, the point is this: they have invoked a compulsive process of the court under a specific pretense. This is an abuse of the court process. They didn't even tell the court what the relevant change in circumstances was.
Right.
They have an obligation under the Civil Procedure Act as well.
Okay.
Comply with those requirements, and if Your Honor is asking what orders we're seeking, we would also seek disclosure orders under the Civil Procedure Act, and we would seek leave to issue subpoenas in these proceedings as.
I'm not dealing with anything like that today, Mr. Kuksal.
Your Honor, we have a right to issue subpoenas.
Mr. Kuksal, I'm not dealing with it today. I'm here to deal with a couple of issues that I'm going to determine at some stage.
But, Your Honor.
Mr. Kuksal.
Subpoenas without the court's leave.
Mr. Kuksal, I'm not going to listen to an application by you now orally for a whole lot of relief that.
Well, we want to issue subpoenas.
Well, I'm telling you I'm not going to hear it. Thank you, Ems.
Okay, one final thing. I think the distinction between the court permitting them to file a particular kind of amendment is that the court and then bringing an amendment by themselves and saying this should be permitted is that in the first instance, the court has predetermined that the kind of amendment being sought is appropriate. It was our understanding that before they file an application for a specific kind of amendment, the court would first approve, review and okay it for that particular sort of amendment to be sought. I think that was clear from the wording. So it's not just that there is a superficial non-compliance. The material prejudice is that they have gone ahead and thought that the kind of amendment that they were seeking they could simply go and seek. It was our understanding that there would be first a discussion about what amendment would be appropriate. Your Honor has certainly not given us the opportunity to just file a proposed amended originating motion. Your Honor has repeatedly clarified that before such a leave.
It's not you don't have an originating motion in this proceeding.
But in other related proceedings, same parties, Your Honor's position has always been that before seeing one, Your Honor will not give us leave to file summons to amend the originating motion because Your Honor needs to make sure Your Honor won't even let us issue subpoenas without first.
Mr. Kuksal, thank you. I understand your point, Ms. Norton. I'm going to go and reflect on matters and return, and I may or may not have further questions for you then. But there's one aspect I just do want to raise with you now before I go reflect about the matter.
Yes, Your Honor, yes.
Which is this question about the form of your summons.
Yes.
Am I right in thinking that if it were done strictly correctly, and I accept that I was loose in my language in the hearing, it's the originating motion that should identify the relief sought, and what your client ought to have done is file the summons saying we want leave to amend the originating motion, and then identified a proposed amended originating motion?
Yes. I can address Your Honor on that now or when the...
No, I just want to hear what you say about that.
Yes. I absolutely acknowledge the concern that was raised by Ms. Zhu at the last hearing on the 28th of November.
Yes.
Ms. Norton, and we went away and we had a think about that. We thought about what was the appropriate course.
Yes.
Ms. Norton, and I agree with Your Honor, with respect, that in the ordinary course, the amendment ought to have been to the originating motion.
Yes.
The reason why we amended the summons was that the relief that was sought in the proceeding had moved on since the originating motion was first filed in October of 2022, and I can show Your Honor how.
But when you say the relief sought, what do you mean? In
the orders sought, so.
Yes, what? But how were the orders sought identified?
They were identified in an amended summons.
Summons. So, the mistake, if there were a mistake, took place at an earlier stage, and you?
Perhaps so.
Were consistent in the process.
That's right. And, Your Honor, we did advert to this issue in our written submissions, footnote 1.
Let me just bring that up. Footnote 1. The application, okay, yes.
So we're in the court's hands. If indeed the application needs to be to amended the originating motion, that can be arranged.
All right.
But as a matter of substance, the amendments that we seek are those set out in the proposed amended summons.
All right.
And I would absolutely accept that perhaps the
So what? What should happen? The originating motion sets out the sort of relief sought and then a summons is brought to get an interim injunction pending that.
yes,
Yes.
yes,
But what you're, in substance, applying for is to amend the originating motion so that it accords with the formulation contained in the document that was called Proposed Further Amended Summons.
that's it, that's so, Your Honor.
All right.
Your Honor, I want to quickly respond to that. This is highly relevant, Your Honor.
Yes.
Very, very quickly. Your Honor, the problem that they have is that their complaint now is about a completely different unrelated matter such that they would have to start a new proceeding to seek the relief that they're seeking now. This proceeding was started because in their view there was a law firm.
Mr. Kuksal, I'm not going to hear from you anymore. You've had sufficient time.
No, but this is in response to what Ms. Norton just said. This is specifically in response. She says that the proposed summons is okay in substance.
Yes.
I'm saying it's not, because it's not because the originating motion sought to stop 3 defendants or 4 defendants from intervening in the affairs of an external manager.
Yes.
That was the purpose of the proceeding.
Yes.
It's their position now that the law firm doesn't exist. There is no external manager. What they're now trying to do is stop us from pretending it's a completely different matter.
Yes. All right. Thanks, Mr. Kuksal. I'm going to close it now. It's 1:15.
Does Your Honor have access to the transcripts of the 20th and 21st?
Mr. Kuksal, I.
Not right now, but when Your Honor goes away to deliberate. I think Your Honor would need to refer to those to see what happened before Her Honor Justice Forbes. We can provide a copy if that helps.
I think I have access to transcripts if I feel the need to look at them.
And, Your Honor, on that point, in case it might assist, I have 3 transcript references where the matters that have been canvassed today were discussed before.
Well, Your Honor, we have to give transcript references as well if they're giving transcript references.
Mr. Kuksal, you've had 2 months to prepare for this.
But that's not fair, Your Honor.
You haven't put in any submissions.
Your Honor, I can give evidence about how many times I was in court.
Mr. Kuksal, I'm not interested. You've prepared your argument and you've come along and you've presented it orally without giving anyone any notice of it at all.
Your Honor, I am being injuncted against use of proprietary material that I own.
All right, I'm going to, well, so perhaps I should just check that I do have the transcript. And this is the transcript of the application before Justice Forbes.
Justice Forbes.
Yes, it's the 20th of October. That's day 1 of that application.
Yes.
And 21st.
Yes, I will.
Would Your Honor like the transcript references?
Well, Mr. Kuksal's going to then need to respond. How long will it take you to put transcript references in?
We can provide highlighted copies of the transcript to the court.
When?
Now, we have highlighted copies of the transcript.
All right, well, I will, so you'll be able to email it to my associate.
And copy them in, yes.
Yes.
And they can do the same.
Well, perhaps.
3 references.
Perhaps if I take your references and Mr. Kuksal, you can send through a document identifying the references you want to.
Highlighted copies.
Highlight, that'd be okay. Yes, Ms. Norton?
So, Your Honor, at page.
What's the date again? Remind me?
The 20th of October.
Yes.
Page 115 of that transcript, there's Mr. Kuksal raised the concern about the irregularity in the originating document.
Yes.
And at line 23, Her Honor asks Mr. Kuksal why that irregularity needs to be dealt with at that time, not at the final hearing. There's further consideration of the matter over on P122, where the senior counsel for the board explained the rationale behind the use of the special procedure. And I would just note also, on page, it's P10 of the transcript, this is moving to the amendment of the summons on P10, line 19.
Are we still before Justice Forbes?
Still before Justice Forbes. It's just earlier in the document. That's where Justice Forbes gave leave to the board to amend its summons to include a reference to a new email address. The litigation team.
Your Honor, that's a misleading submission. I must address the court about that. What Her Honor did, quite improperly, is that without determining the irregularity of the summons, amended the summons anyway.
All right,
What, and Her Honor explicitly reserved the decision on whether or not there was in fact an affidavit filed in the proceeding, whether it was admissible. This is also reflected in the judgment that Her Honor said. Her Honor emphasized that she has not made any findings in relation to the substance of the application.
All right.
And, Your Honor, there's another part. The injunctive relief was granted in circumstances where Her Honor wanted to make an order at any cost at the end of the hearing and the matters had not been sufficiently covered. And Her Honor had been misled by the senior counsel, acting for the Legal Services Board, in holding that because the injunction.
Mr. Kuksal, tell me what your point is in one sentence. Don't give me the argument, tell me, give me the conclusion that you're trying to.
There was no basis to grant the injunctive relief.
All right, so you say.
It was only granted because the senior counsel misrepresented to the court that the court could grant it without any preconditions.
Thanks, I'm going to come back at 2.30. We'll adjourn the court till then, please. Mr. Kuksal submitted that he should not be ordered to pay costs, on the grounds that the proceeding was invalidly commenced by the board, because, first, it was commenced by originating motion, and the requirement of Rule 4.05b of the Supreme Court, General Civil Procedure, Rules 2014 were not met. It was commenced by originating motion, but was not accompanied by a valid affidavit, and it was initiated as part of a conspiracy of unlawful conduct directed at him by the board and Victoria Police, and various people in those organisations. He submitted that the validity of the proceedings, including whether it was initiated as part of a conspiracy of unlawful conduct directed at him by the board and Victoria Police and various people in those organisations, had to be decided before any costs could be ordered. That I need to first determine whether there is a proceeding. The other defendants adopted Mr. Kuksal's submissions. I do not accept these submissions for a number of reasons. First, Rule 4.05b provides that a proceeding shall be commenced by originating motion whereby or under any act an application is authorized to be made to the court. The application is expressed to have been brought under S 4775 of Schedule 1 of the Legal Profession Uniform Law Application Act 2014. Section 447 provides as follows, and then I will set out what it says in 447, and in particular saying that the Supreme Court may grant, on application under sub S2 of the Supreme Court, may grant an injunction. In those circumstances, I am not satisfied that Rule 4.05b does not authorize the commencement of this proceeding by way of originating motion. More fundamentally, the rules are the servants, not the masters of judicial process. The defendants did not identify any prejudice that they have or will suffer by reason of their facing a proceeding commenced by originating motion rather than writ. The principal practical difference between the two forms of proceeding is that a proceeding commenced by writ has pleadings and a proceeding commenced by originating motion does not. It would be open to the court to order pleadings even in a proceeding commenced by originating motion. When I inquired of Mr. Kuksal, he did not indicate that he would be seeking pleadings. Also, and conclusively, Rule 2.04 gives the court power to dispense with compliance with any of the requirements of the rules whether before or after the occasion for compliance arises. And Rule 2.02 provides that the court shall not wholly set aside any proceeding or the originating process by which the proceeding was commenced on the ground that the proceeding was commenced by the wrong process. It follows, too, that if the proceeding were improperly commenced by reason of a failure to file a proper affidavit at the time of issue, as to which I make no finding, that is a matter that could be sorted out other than by ordering that the proceeding be wholly set aside. I acknowledge that the defendants raised this issue before Justice Forbes early on in the proceeding and that the issue was not resolved. This fact does not cause me to alter my conclusion expressed above. I am not in a position, now, to determine whether this proceeding was commenced as a result of an unlawful conspiracy. That, however, is no reason why I ought not now to make costs orders as anticipated in my earlier reasons. The costs under consideration relate to certain court attendances and applications, the expenses of which are not related to the issue of whether the proceeding was commenced for an improper purpose and are not the costs of the proceeding as a whole. Ms. Zhu submitted that no cost should be ordered because Mr. Rapke, whose management of the law practice was integral for the proceeding being commenced, is no longer the manager. She was critical of the board and Mr. Rapke for not informing the court of this fact until recently. She did not suggest, however, that she was unaware of Mr. Rapke ceasing to be a manager until the board informed the court. Mr. Kuksal, in substance, adopted and emphasized this argument. I proceed on the assumption that Mr. Ansell did too. In this respect, as noted above, the interim injunction made was not limited to the involvement of Mr. Rapke but covered the defendant's conduct more generally, with the proposed amendments, do likewise. Without expressing a view on the obligations on Mr. Rapke or the board to inform the court, or indeed when they did first inform the court, I do not accept that their conduct disentitles the board from any costs to which it would otherwise be entitled for the court attendances and associated expenses presently under consideration. In my view, it is appropriate and in the interests of justice generally that I make costs orders as they relate to those identified issues now. The defendants did not file any material in relation to the quantum of costs sought and did not address me on that issue. In terms of the costs of the 17th of August 2023, the 28th of November 2023 and the 3rd of November 2023, in my view, the board's costs of preparing for and appearing at the 17th of August 2023 directions hearing should be paid by the defendants. It was the defendants' conduct that caused that day to be wasted. No explanation has been given by the defendants for their conduct. The board should not be out of pocket by reason of these matters and its costs should be paid on an indemnity basis. The defendants should also pay the board's costs incurred as a consequence of the failed recusal applications. That includes the costs of the board's appearance on the 3rd of November 2023. The board was required to appear on the 3rd of November 2023, if only because it was anticipated that, if the recusal application was able to be disposed of expeditiously, the mention in the proceeding would take place on that day. The board was also properly entitled, in my view, to listen to the recusal application and decide whether or not to take a position in relation to it. The recusal application is a serious matter. These costs also include the costs of appearing on the 28th of November 2023 to receive judgment. The recusal application was, in my view, without merit and would not have been brought by a party properly advised. Further, the defendants did not provide material in advance, despite being required to do so. The board should not be out of pocket by reason of a failed recusal applications and its costs should be paid on an indemnity basis. I propose to fix costs so as to avoid the time and expense associated with taxation. The board's solicitors have filed an affidavit in which it is deposed that, and these figures are exclusive of GST, on the 17th of August 2023 their fees for $623.45, and counsel charge, $454.54 for the 17th of August 2023 hearing. Those figures are half the total amounts charged for that day because another unrelated matter was also heard. I am satisfied that these amounts are reasonable and that it is appropriate to fix the board's cost for that day in the amount of $1,077.99. On the 3rd of November 2023 their costs were $2,022.20 and counsel's fees were $3,272.73 for the 3rd of November 2023 hearing. It is noted above a recusal application is a serious thing and the board was entitled to take it seriously, including by briefing appropriately experienced junior counsel and by sending an experienced practitioner to instruct at the hearing. This was particularly so, given that the defendants had not provided relevant material sufficiently in advance. I am satisfied that these amounts are reasonable and that it is appropriate to fix the board's costs for that day in the amount of $5,294.93. The 28th of November 2023 the board did not engage counsel for the 28th of November 2023 hearing but was represented by their solicitors and their solicitors' fees were $505.50 for appearing on that day. I am satisfied that this amount is reasonable and that it is appropriate to fix the board's costs for that day in the amount of $505.50. Turning to the application to amend. The first issue is whether it should be allowed. The board applied, by a summons filed the 15th of December 2023, to amend its claim. The proposed amendments first removed any application for an injunction that the defendants be restrained from obstructing Howard Rapke in his capacity as manager of the law practice, conducted by People Shop Pty Limited because Mr. Rapke has ceased to be the manager of the law practice. And it maintained the application for a final injunction restraining the first, second, and fourth defendants, that is, Mr. Kuksal, Mr. Ansell, and Ms. Zhu, from engaging in certain conduct relating to the law practice and varied the form of injunction sought and added an application for an injunction restraining the second defendant, Mr. Ansell, from engaging in legal practice generally whilst he does not hold a practicing certificate. The board filed its material in accordance with the directions, subject to what I say later. The defendants, again, did not file any material in response by the time required. For the purpose of the application, the board's affidavit material established, in the absence of any evidence to the contrary, that Mr. Ansell has not held a practicing certificate since the 18th of October 2022, but that Mr. Ansell has, since that date, communicated with email addresses associated with the law practice and has, on occasions, described him as a legal director of the law practice and that documents of a legal character have been prepared by the law practice, or the legal practice. The defendants submitted orally that they should not pay the plaintiff's costs of the amendment because the board had not made its application in the appropriate manner, because it failed to circulate a proposed amended originating motion, which was what the court had ordered it to do forthwith, and it sought leave to amend its summons rather than to amend the originating motion itself. Their understanding was that there would first be an argument about the scope of what amendments would be permitted, and only then would there be an argument about the precise document. The defendants are right that the board should have prepared and circulated a proposed amended originating motion forthwith, and its summons should have sought leave to file and serve an amended originating motion in the form circulated. Further, the summons that was filed was headed, "Proposed further amended summons on originating motion," which make it read as if it were an application by summons to amend an earlier summons. Possibly the summons was the process by which the application for an interim injunction was brought before the court. So much was acknowledged by the board in its written submissions, where it stated that the application to further amend the amended summons was made on the basis that the document represents the most recent iteration of the relief sought in the proceeding and that, in the alternative, the plaintiff applies to amend the originating motion to include relief in the terms set out in the proposed further amended summons. Significantly, however, the summons filed made it sufficiently clear, in my view, what the board was seeking. The summons it filed said the following: "You are summoned to attend before the court, constituted by a judge of the court, on the hearing of an application by the plaintiff for judgment or an order in respect of the relief or remedy sought in the originating motion, amended as follows." The summons then set out the amended substantive relief, marked up, that it was to seek in the originating motion. In those circumstances, I am satisfied that the applicant sufficiently put the defendants on notice as to the amendments that were being sought, and that the irregularity in the formulation of the application did not occasion the defendants any prejudice. I am also satisfied, on the material provided, this is, of course, a preliminary view only, that the proposed amendments raise issues that call for proper evaluation and are not an abusive process. I will grant leave to the board to amend its originating motion, substantially in accordance with its summons filed the 15th of December 2023. In terms of the costs of the application to amend, it was appropriate that the board identify the basis for its proposed amendments, and I do not consider that the defendant's failure to consent is a reason to order the board now to pay the costs of the application to amend. Equally, the amendments sought arise out of matters that have arisen since the proceeding was commenced. This is not a case where the amendments have come about because of some anterior defect in the draft. Accordingly, I will order that the costs of the amendment be costs in the proceeding. So in terms of the disposition, I will order that the first, second, and fourth defendants pay the plaintiff's costs of the 17th of August 23, the 3rd of November 23 and the 28th of November 23 hearings, and of the application for costs, fixed in the sum of $14,346.31. I will give the plaintiff leave to file and serve an amended originating motion, substantially in accordance with the amendments proposed in its proposed further amended summons, on originating motion special procedure filed on the 15th of December 2023, and I will order that the costs of the amendment be costs in the proceeding. Okay, next issue we have to deal with then is,
Your Honor, we'd like to be heard in relation to the preliminary view expressed by the court about the appropriateness of the summons.
No, I've made my ruling. I'm going to allow the amendment. What I was clarifying is that by saying that there's a basis for the amendment, I'm not foreclosing, I'm not finally deciding that the application, that injunctions will ultimately be made. That's a matter for.
But Your Honor said that it was, on evidence, unopposed that Mr. Ansell did not have a practicing certificate.
Yes, that's right.
Your Honor, we've filed loads of material, multiple affidavits, and also it is a matter before Your Honor in another proceeding.
It's over. It's over. You have to take it on appeal. I've given my reasons.
But Your Honor,
Mr. Kuksal,
there is a judicial determination pending.
Mr. Kuksal,
in relation to whether or not.
I have made my decision. I'm going to allow the amendment and I'm going to order those costs.
Okay, would Your Honor give us a brief period to appeal, just in relation to the amendment because.
No, I'm going to make the order. I've made the order, and if you appeal it, you appeal it. You have appeal right.
But would Your Honor stay the?
No.
Your Honor, that carries.
No. If you want a stay, you can get a stay from the Court of Appeal.
But Your Honor, if Your Honor makes the order or perfects the order, that has immediate prejudice in relation to Your Honor making a judicial determination.
I don't agree, Mr. Kuksal.
Your Honor, the uniform law states that any decision taken by the board when that is subject to an appeal, it is in effect a nullity if the court finds so. This is a superior court.
Mr. Kuksal, look, I'm sorry to cut you off. I've read my reasons, I've pronounced my orders. I'm not going to stay them. You have whatever appeal rights you have, and of course, you can exercise them. And if you can persuade an appellate court that my orders should be stayed pending the appeal, then the appellate court will stay my orders pending the appeal.
But Your Honor, your orders will take effect once they are perfected.
Well, yes, my order granting them leave to amend their application. Is that the order you're concerned with?
That's right. Yeah.
Okay, yes, that's right. They will have leave to amend their application.
But the validity of the proceeding, Your Honor, has not decided. So what will in effect happen is, in sanctioning that process, it can no longer be decided that.
Mr. Kuksal, this is what you'll have to take up with the Court of Appeal. Now, I'm not going to stay my orders.
But then you're in effect deciding the validity of the proceeding, because
Well, this is the argument you can present to you'll just have to say to the Court of Appeal that I made the wrong decision.
But once your order takes effect, the nullity argument can no longer be raised. So we're saying, in normal circumstances in these cases, the court gives a short period before the effect of the order takes place.
I don't accept that. Orders take effect when they are made.
Unless
I've got the ability to stay the effect of my orders, but it's not ordinarily done if people make a costs order or a.
We're not talking about the costs order.
It's not ordinary. I don't accept your suggestion that it's ordinary to grant a party leave to amend.
No, I'm not saying it's.
Stay the effect of that order to allow someone to appeal.
What I'm saying is that, in these circumstances, there will be a permanent prejudice, and where there is a possibility of a permanent prejudice on an undecided matter that we've previously raised with the court which has been decided in our submission without, well, I think Your Honor has noted that there's no judicial finding of fact. In those circumstances, because it would be an order of this court, which is a superior court, and it has the potential of effectively working as a finding of fact, we request that the amendment order take place a week later.
What I was trying to convey, Mr. Kuksal, is that I wasn't persuaded by your arguments that the proceeding was invalid because of the failure to comply with the orders, but I wasn't making a determination now, nor could I, about whether the proceeding is invalid in some way because it's been commenced as a result of an unlawful conspiracy.
But, Your Honor,
are we on the right? Are we on the right? Are we ships passing in the night, or are we?
No. In relation to the first matter, whether or not Your Honor should exercise the discretion to regularize an irregular proceeding is something that Your Honor has to consider after considering whether or not the proceeding is appropriately commenced. What?
Well, I am not persuaded that I take the view that the rule authorized the commencement of a proceeding, and if there were a problem with that, it could be regularized.
But
by granting various exemptions, and that's no reason not to grant an amendment, and I have made it clear that I have not made a decision on your argument that the whole proceeding is void or defective in some way because it's the product of an unlawful conspiracy.
Okay, so, Your Honor, there's two things about that. First thing, the invalidity was argued on the basis of not only non-compliance with that rule but also the absence of affidavit.
Yes.
Of added affidavit.
Again, I dealt with that. I'm not persuaded by that.
The admissibility of the affidavit was challenged immediately.
Mr. Kuksal, I repeat, you've just.
No, all we're seeking, Your Honor, is a week interim period before the amendment order takes effect because, in effect, what that order will do is legitimize the proceeding.
Well, Mr. Kuksal, I'm against you. I'm going to make that order, and if you want to, you can probably go to the Court of Appeal and get the order set aside if you want.
But that does not.
You can persuade them.
That does not put us in the same place.
Mr. Kuksal, I've made my decision.
Okay, so is Your Honor saying that the proceeding is otherwise legitimate?
I am saying, the order I'm making is granting leave to the plaintiff to file an amended originating motion substantially in the form of the amendment identified in the summons.
Without determining the validity of the proceeding as it relates to the abuse of process argument.
Yes.
And is Your Honor determining that the affidavit that was filed was admissible?
I determined as I've determined. I've taken the view that even if the affidavit were problematic, that would not be sufficient reason to prevent me granting leave to amend. But, Mr. Kuksal, look, I don't want to sort of get into a discussion with you where I'm altering and varying my reasons or clarifying them. I mean, I've read them out. The substance of them will be in there. I will do my best to publish something if not today, then tomorrow, and you'll do what you wish to do. In the meantime, we've got directions to make for the further.
Yes, Your Honor, we seek an order pursuant to S55 of the Civil Procedure Act and S55A that there should be discovery in these proceedings.
All right, well, you can file an affidavit. You file a, if you want something other than.
We're asking for discovery.
All right.
We don't need to file.
Have you put the board on notice?
Plenty of times, but, Your Honor.
Well,
we don't even need to do that for discovery. Discovery can be sought by any party. It's an inherent statutory right.
Of course, Mr. Kuksal, that's right. And it can be opposed. But if we're going to have an argument about, first of all, I should check with Ms. Norton. Seeking an application for an order for discovery.
To my knowledge, it hasn't been foreshadowed, Your Honor.
Do you know what the board's position would be on an order that'd make discovery?
I couldn't say, Your Honor, without instructions.
All right.
Your Honor, it can't be opposed by the prosecutor in the proceeding because they have a prosecutorial duty of disclosure anyway.
Mr. Kuksal, if we're going to have an argument about discovery, it's got to be made on some notice.
But Your Honor,
No buts.
the prosecutor cannot.
Mr. Kuksal, why have you not put anyone on notice that you're going to be seeking order for discovery?
Because they have a statutory obligation.
Okay, that's not an answer.
We don't have to put them on notice.
You don't have to, but if you make an application and people haven't been put on notice, then you can't complain if the application is not heard straight away.
No, Your Honor, it's a complaint that they have not complied with their disclosure obligations so far.
That's a different point.
No, it's the same point. What we're saying is that because they're not acting reasonably and not complying with their disclosure obligations, instead of wasting more time, we want the court to make orders that they comply with their disclosure obligations. That's all that we're seeking.
Okay, and how are you going to satisfy me now that they have not complied with their disclosure obligations?
Because they've not presented any evidence to us. As the prosecutor, they are required to present all the evidence that they've collected against us. They've not provided us with anything.
Keep talking about the prosecutors. They're an application for an injunction.
Your Honor, I cited 2 authorities.
This is a proceeding seeking an injunction.
Yes, it was the same thing in those proceedings. It was the Legal Services Board actually seeking injunctive relief.
All right, let me make a note. So in terms of directions for this hearing, I'll make a note. What orders do you seek?
We seek orders under S55 and 55A of the Civil Procedure Act that the Board disclose all relevant documents.
Disclose or discover? What's the form of order you want?
We are ambivalent in relation to the
Well, tell me what the order is you want.
disclose.
Disclose.
So both.
All documents.
Relevant to these proceedings within the context of section, so relevance is determined by S26 of the Civil Procedure Act.
Section 26.
Section 26 of the Civil Procedure Act. And it's determined by common law principles. So we say that they have a 2-pronged source of disclosure obligations. 1, because they are the prosecutor. They are the prosecutor, Your Honor, because they're enforcing statutory.
Let me just bring up Civil Procedure Act section
26.
55 first.
Also, the court has an overarching duty to make appropriate orders for discovery.
All right, so you want an order for the discover all relevant documents.
That's right. Now, Your Honor, wherever the enforcement of a public obligation is involved.
But what else do you want? I'm just trying to get a list of what orders you want.
So all relevant, all documents that will be relevant.
Yes.
To an issue in these proceedings.
Yes. You want the discovery? Yes.
That's all we want.
Yes.
We want discovery of all relevant documents.
Have you put in all the material? I'm assuming that the grant of leave to amend remains undisturbed on appeal. Make directions on that basis. Have you put in the affidavit material you want to rely on the proceeding?
In these proceedings?
Yes. Or do you say?
We want to put more material then, but also, after they've discovered the relevant documents, that's when we should have a final opportunity.
Yes.
To put the last bit of affidavits because.
All right, Ms. Norton.
But, Your Honor, may I just add one more thing? They are prosecutors because the enforcement of a public obligation, the enforcement of statutes, makes them a prosecutor.
All right, you would say, even if they're not prosecutors, even if it's a civil.
That's civil procedure.
They've still got to give.
Yes, but any entity that enforces public law is a prosecutor.
You're relying on the Civil Procedure Act again. I thought you'd indicated at some stage that you weren't sure whether it applied. Any proceeding in a court, other than a criminal proceeding. So do you say that this proceeding is a criminal proceeding or a quasi-criminal proceeding?
This is a quasi-criminal proceeding. In fact, in Beaver it was said that this is a sui generis proceeding. It's a proceeding of its own sort, but
I want to ask you, do you say that it's a quasi-criminal proceeding for the purpose of the definition in the Civil Procedure Act?
It's not strictly a quasi-criminal proceeding. It's a proceeding of its own sort. The High Court has said this in Beaver.
Do you say that the Civil Procedure Act applies to this proceeding?
I've done some further research and essentially, the court's civil procedure rules can apply to these proceedings.
Mr. Kuksal, does the Civil Procedure Act? If you tell me you're not sure.
It's not a simple answer. It depends on what the court decides. The court can decide in these proceedings that the standard format is the civil procedure rules. But then the court has to additionally consider in certain circumstances whether they're adequate.
You've indicated to me that you wanted me to make an order under a power contained in the Civil Procedure Act.
Yes, we can make that application.
That doesn't apply if it's a quasi-criminal proceeding.
This is not a quasi-criminal proceeding.
All right, well, that's I thought you were. The plaintiff is a prosecutor.
Yes.
But it's not a criminal or quasi-criminal proceeding.
No, because the enforcement of a public law makes him a prosecutor.
All right.
For instance, tax authorities prosecute for the payment of taxes all the time. They're not considered to be criminal proceedings.
Tell me quickly what the difference is. Are you more likely to get an order for discovery if I characterize the board as prosecutors, rather than?
They are prosecutors because they're enforcing a public law. Their right to commence these proceedings does not come from contract.
Well, it looks like the next issue. Ms. Norton, sit down for a moment. Mr. Kuksal.
Your Honor, if I...
Mr. Kuksal, just sit down for a moment.
Yes, Your Honor.
Ms. Norton, Mr. Kuksal has identified that he wants an order for discovery as the next step in this proceeding. Subject to hearing from you, ordinarily people aren't required to put their final material in until there's been such discovery as there will be. I'm tending to think that the next step in this case, then, will have to be to determine whether or not to make an order for discovery and so forth. What do you say about that, and are you able to deal with it now, or do you need to get instructions?
I can say this much, Your Honor. I believe you have before you the Civil Procedure Act, S55.
Yes, having said that, I'm sure I've got the power to order discovery.
Of course, but it needs to be discovery that the court considers necessary or appropriate. Now, I'm not aware in proceedings of this nature of it being commonplace for orders for general discovery to be made, which is effectively what Mr. Kuksal.
What I'm really trying to get at is, how and when do we deal with this? Are you saying you want to engage with this application now? I asked you a moment ago, and I got the impression you hadn't got instructions on the client's attitude to it. I'm happy to just wait outside for 3 minutes. You can talk to your client.
Yes, thank you, Your Honor.
And maybe even talk to Mr. Kuksal, and Ms. Zhu and Mr. Ansel. Mr. Kuksal, I hadn't appreciated this was what he was going to agitate today, but that might be. I don't know. If he wants an order for discovery, at some stage I've got to turn my mind to whether he should get one or not. The question is, how and when do I do that?
Your Honor, we submit that there's binding authority of the Court of Appeal on this court.
But that's for an argument.
In terms of their prosecutorial obligations.
I don't want to argue it now if I'm not going to argue it now. If I have to decide an application that they give discovery, then I will hear that, and I can hear your arguments then about the obligations on them, Mr. Kuksal.
But what we're saying is that we don't think that there should be an argument about that.
What you're saying, your case, that shouldn't have an opportunity to argue against it.
We're asking for relevant documents.
All right, Mr. Kuksal, you might be right. But I'm going to stand the matter down, so I can, if the board says to me, yes, we'll give discovery, or the board might say, we've given discovery of such documents.
They're model litigants, Your Honor.
The board might say, we've got no obligation to give discovery, because this section of the Act says that I never have to give discovery. I don't know.
Your Honor, if there was discovery, it will be 2 applications against them and the practitioner who opposes it because they relevantly have model litigant obligations.
Had you told Ms. Norton before?
We don't need to. They're prosecutors.
I know you keep saying everyone is a model litigant.
The regulation says that.
Everybody's meant to act properly. Now, am I right in thinking that this is the first, just now, is the first time?
No, it's not.
You've conveyed.
No, it's not.
You haven't conveyed to Ms. Norton.
Your Honor, we've repeatedly accused the legal services.
Mr. Kuksal, you're interrupting me.
Sorry.
I'm just trying to work out the practicalities of today's directions hearing. And the impression I've got is that, after I gave my ruling, you stood up and said, now we want an order for discovery, and Ms. Norton, from the facial expressions and the communications between her and her instructors, hadn't expected that you were going to be making that application. So I was inquiring whether you would have any discussion with her and said, just so you know, we want a discovery order today.
Your Honor, we have subpoenaed Your Honor's chambers to seek leave to file subpoenas in relation to the board's actions against us.
Yes.
We have repeatedly emphasized that we are seeking disclosure. We have accused them on affidavit of suppressing evidence.
Mr. Kuksal, I'm just going to stand the matter down. I'll sit outside just for a couple of minutes so Ms. Norton can get instructions. And if we have to set a time to hear an argument about discovery obligations, we'll do that. Stand the matter down temporarily. Yes, Ms. Norton.
Thank you, Your Honor, for that indulgence. I have instructions that an order for discovery will be opposed by the board. It's not customary for order of discovery, and certainly not general discovery in the terms foreshadowed by Mr. Kuksal, to be made in proceedings commenced by originating motion.
I mean, just as I didn't want Mr. Kuksal to argue.
No, and I'm not going to argue it, Your Honor. Please let me reassure you. In my submission, the appropriate timetable from here will be as follows. Firstly, there should be an order that Mr. Kuksal by a date in the not-too-distant future, and I have in mind something like the 1st of March, which I think is about 10 days hence, should identify in writing the categories of documents that he on behalf, I assume of the defendants seek from the board, and should also identify in writing the basis on which the defendants say that discovery of documents in those categories is necessary or appropriate pursuant to the test in S55 of the Civil Procedure Act. In the event that that deadline is complied with, that is, that there is, effectively, an application for orders on foot by whatever the deadline for compliance is, then the board be given a further period of approximately 10 days to put on materials in response. It ought to be the case that that application could then be determined on the papers, but would be in Your Honour's hands naturally as to whether that's appropriate once Your Honour's seen the materials. In my submission, it's also appropriate that there then be an alternative timetable, if you like, that would provide for the further preparation of this matter for final hearing in the event that there is no application lodged by the defendants within the time provided for under the orders.
All right, look, I think, all right.
Your Honor, may I?
Look, I will.
And in.
I'm not immediately attracted to that idea because what do people do? Start preparing it being whether I do or don't, but.
Well, that order would only be engaged if there's no application on foot by the deadline, and if there is, that order would fall away.
The other possibility would be if we just have another mention if.
Yes.
All right, well, I'll.
Yes, Your Honor.
Yes.
The difficulty which another mention is that's likely to be another day in court.
Yes.
There's a lot of cost associated with that for matters that sometimes could be dealt with on the papers.
Right, Mr. Kuksal.
We'd like to issue a subpoena, Your Honor. We have a right to issue subpoenas. We would like to issue subpoenas in these proceedings.
So you don't want discovery, an order for discovery now?
No, what we're saying is that.
If
the court is going to require us to file submissions and so on, too, what the court needs to first do is determine what the extent of the disclosure obligations are of the board.
Mr. Kuksal, I respond to applications. I'm not just going to start making declarations about what disclosure obligations are.
Okay, so we're seeking discovery orders, but we're seeking subpoena as well.
All right, so.
One thing doesn't have to be contingent on the other.
All right, let's just deal with the discovery. Are you going to apply to me for an order that the plaintiff make discovery of categories of document or?
We had applied today.
Okay.
But in the event that the court.
Are you going to pursue that application? Because I'm going to.
If the court wants to hear argument about it, then we want to first issue the subpoena.
Okay, well, I can tell you, then, so you know, I'm not going to make a discovery order without hearing argument about it.
Okay, we want to issue subpoenas.
Okay.
In that case.
Do you need my leave to issue subpoenas?
Only because there is a rule which says that, well, we don't need your leave, Your Honor, as such. Essentially, litigants have the right to issue subpoenas in civil and criminal proceedings. The civil procedure rules of the court say that we can't issue subpoenas through the prothonotary like a legally represented litigant can. We have to issue them during proceedings before the court, but it does not.
So you need an order from me?
No, we don't. We essentially need this court to seal the subpoena that's issued rather than the prothonotary sealing it.
Okay, so I have to decide whether to seal it.
Effectively, yes, but the test is whether it will be an abuse of process.
All right, so are you going to
provide a copy of this? Yes.
Provide draft subpoenas with argument about why I should issue them?
No, because Your Honor.
All right, and do you accept that I should hear the other side before I issue them?
No, I have explicit authority. In fact, I've won proceedings about why they cannot be heard first.
Okay, and if I do issue the subpoena, they can always apply to have it struck out.
Set aside. Yes, that's right, but their right to set aside only kicks in at the point where they have been asked to produce because they have to. The opposition has to be on very well-defined grounds.
No, they can apply, unless something's changed, they can apply to have the subpoena set aside the moment it's served on them.
On what basis, though? They have to identify the basis.
Well, they have to have a reason to.
Yes, so if it's oppressive, then they have to file an affidavit setting out what efforts they've made, why it's oppressive, and so on and so forth. I've done at least 50 proceedings on subpoenas, Your Honor.
Okay.
I have every authority on the subject memorized.
So do we put discovery to one side now, and we'll just talk about subpoenas?
Yes, that would be the most expeditious.
So you're withdrawing the application or not pursuing the application?
At this stage, we're not pursuing it until the determination of the subpoena, I guess.
So the next step is for you to draw up some
Subpoenas.
subpoenas and send them to my chambers.
That's right, and they don't have a say in it.
So you resist them even seeing the subpoenas?
They can see them. Every communication we send to Your Honor's chambers should be sent to them.
Yes.
But they don't have a say on whether or not the court issues them. The authority for this, there's loads of them, but Wayne versus National Employers Association. The only instance in which.
Who will the subpoenas be addressed to?
The Legal Services Board.
Just the board?
No, there will be other parties as well, but the legal services.
Well, who are the, you don't know yet. You're still thinking.
We will have to decide, but definitely the Legal Services Board.
Plus other individuals?
Yes, employees of the firm.
Employees of what firm?
People Shop Pty Limited.
People Shop. Sorry, I thought you meant the firm of solicitors acting for the board or something. Yes.
No, not.
So there'll be a number of subpoenas addressed to the board and to certain individuals, and they'll be subpoenas to produce documents.
Produce documents and give evidence in some cases. Now, Your Honor, I must also emphasize that S55ZH of the Judiciary Act essentially limits the application of legal professional privilege for government bodies. There's a number of authorities on the subject.
Well, we'll cross that bridge when we get to it.
Yes.
So have you prepared the subpoenas already? Draft proposed subpoenas?
We have copies of draft subpoenas, but if the court will decide them now, we can provide them.
No, I'm trying to work out.
What time frame?
Well, what to do next? Should I give a date by which you are to?
Yep.
Circulate to my chambers copying the defendants the proposed subpoenas the subpoenas that you want issued?
Yes, we can provide them to Your Honor's chambers by Thursday and.
What's Thursday? The what?
22nd.
22nd of
February, so just the copies of the draft subpoenas.
Yes.
Only those. We don't expect that.
You say that you have almost an as of right to have the subpoenas issued.
I think several courts of appeal and the High Court says that.
That's, yes, no.
We have.
And it's up to the respondents, to the addressees of the subpoenas once they've been served with the subpoena to raise any concerns they have about the subpoena.
Yes, so, Your Honor, the letting authority on the subject is Blacktown City Council.
Right, so.
Versus.
Ms. Norton, do you accept that position is right, or do you wish to contend that you should be heard before the subpoenas are issued?
I think that would be the orthodox course, Your Honor. I'm just looking at Williams' civil procedure presently in relation to the right to subpoena. So subject to the power of the court to set aside the issue of services the subpoena is oppressive or as an abuse of process, any party is entitled upon their request to have the subpoena issued.
Yes.
I think it would be appropriate if a basis for setting aside a subpoena is that it's oppressive or an abuse of process. If we're on notice of the subpoena in advance of it having been granted for us to put on any submissions, we might want to in relation to those matters. Rather than have the court issue the subpoena as a matter of course and then put the onus on us to come and have it set aside.
Your Honor, it's not about that. It's about a right. They do not have a right. Several courts have. May I cite some authorities to Your Honor?
Mr. Kuksal, not now. Not just now, please.
But I'll just provide them as reference and Your Honor can refer to them.
All right.
So Your Honor, the letting authority on the subject is Waind, W-A-I-N-D.
Yes, that's an old New South Wales case.
That, a Court of Appeal case, and it's been adopted repeatedly by one.
Yes, I know it talks about subpoenas, yes.
It sets out the whole process for subpoenas.
Yes.
So it's National Employers Association.
I know Waind. What page or paragraph? This is in support of the proposition that
they don't have a right to.
The addressee has no right to interfere.
Not the addressee, the party. They will be in, both the party and the addressee. So the only reason that they know that we're about to issue subpoenas is because they're a party in this proceeding.
Yes.
They don't have a right as a party to address the appropriateness of pursuing subpoenas to any potential witness or any provider of documents. Only the party that has been subpoenaed.
So what would I do if you produced a subpoena that was addressed at, a subpoena that was, on its face, an abusive process?
Then Your Honor will not issue it. But Your Honor will probably.
So I have to assess whether it's an abusive process to some extent before I issue it.
So the test is laid out in Blacktown City Council.
Blacktown City Council.
Where it says, so this is a leading authority of the Court of Appeal New South Wales. It's been hailed by the Queensland.
What's the authority by the citation?
Your Honor, just bringing it up. So it's Secretary of the Department of Planning, Industry and Environment v. Blacktown City Council 2021 NSWCA 145. So judgment of President Bell of the Court of Appeal of New South Wales. His Honour has basically said that the law in relation to subpoenas has seen a sea of changes in the last few decades.
What was the citation?
2021 NSWCA 145. We can provide the court with
145, just want the, yes.
With a short body of excerpts from various authorities in relation to the subpoena issues. We can provide the court that, with that when we provide the draft subpoenas. But in essence, the only consideration here is apparent relevance. So if we were subpoenaing Mr. Scott Morrison, for instance, about, his vacation somewhere, because of something that we're saying would assist us in this proceeding, obviously that doesn't ostensibly relate to any issue that we would be concerned with in this proceeding.
All right.
But if we, for instance, subpoena the board in relation to all the complaints that they've received against the firm or myself, or the board in relation to any matter that concerns any of the defendants in these proceedings, then that is ostensibly an issue that has apparent relevance.
Yes.
Now, Blacktown sets out the various grounds on which apparent relevance may be established. Credibility is a very important criteria.
That's right. So I understand. So
if he asks you.
So the first thing though is to set a date for the plaintiff to file its amended originating motion. What's the date by which that can be done?
It could be done by Friday, Your Honour.
Let me just bring my calendar up.
It'll be the 23rd.
So that can be done by the 23rd of February 24. Now, Mr. Kuksal, your subpoena should, I think, be after that because the issues are going to be, what's in issue is assessed by reference to the amended application.
Yes, and also the arguments that we're raising against them.
Well, potentially that's right. So do you want, of the 1st of March?
Well, potentially that's right. So do you want, of the 1st of March?
So by the 21st of March, the defendant is to circulate.
So by the 21st of March, the defendant is to circulate.
The defendants are to circulate any proposed subpoenas.
The defendants are to circulate any proposed subpoenas.
Provide, yes, sorry, yes, but as you say they get circulated. Provide to chambers any proposed subpoenas.
Provide, yes, sorry, yes, but as you say they get circulated. Provide to chambers any proposed subpoenas.
And you want to say also, with a short note.
And you want to say also, with a short note.
Should I say with the submission in support?
Should I say with the submission in support?
No, what you're saying, aren't you, is these are the subpoenas, they should be issued.
No, what you're saying, aren't you, is these are the subpoenas, they should be issued.
I'm just going to give you leave to put in a document telling me why they should be issued.
I'm just going to give you leave to put in a document telling me why they should be issued.
All right.
At this stage we should not be required to do that. In fact, the court would be acting contrary to the law of evidence if the court, essentially, takes objection on behalf of the parties. What the court would be doing is taking objection on behalf of the parties, essentially. If the test is based any higher than apparent relevance. In fact, I've submitted authorities to Your Honour previously on the Evidence Act. Even if evidence is inadmissible and no objection is taken, it becomes admissible, especially in civil proceedings. It's not for Your Honour to play an inquisitorial role.
But for some reason, the rules require me to decide whether to issue a subpoena, not the registry.
Not you. So the difference is that it's the production of documents and where they should be produced. My understanding of the rule is that when they're issued through the prothonotary, because the documents will then be produced to the prothonotary and they will only be produced to a lawyer. Lawyers then have certain obligations to the prothonotary, for instance, not taking the documents that have been produced outside of court and so on in a way that cannot be policed for self-represented litigants. We consider the rule to be in contravention of the Charter of Human Rights and Responsibilities, and it's an issue that we're raising in appeal. That the rule violates the right to due process in proceedings. But in any event, there doesn't have to be a judicial determination about the legitimate forensic purpose of the subpoena when no objection has been taken. The only thing, even that, Your Honour, the prothonotary is bound by the rules to not issue the subpoena if it is a flagrant abuse of the court process.
Yes.
The prothonotary is bound by that requirement as well. And what Your Honour would be doing in issuing the subpoena would be exercising an administrative role, not a judicial one.
All right, well, look.
If I might be heard briefly.
I think what I'm going to do, Mr. Kuksal, is give you, the first step is for me to see the subpoenas that you want to get issued. And see what you've got to say about them before I decide what next happens.
We would subpoena all the documents that the board has in relation to the defendants and the.
I've got to see them. You've got to formulate the first step, so I'll give leave for the plaintiff to file and serve the amended originating motion by 4 p.m. on the 23rd of February, and I will direct that the defendants provide to my chambers a draft of the subpoenas that they seek to have issued by 4 p.m. on the 1st of March.
Is that Monday, Your Honor?
That's the following. I think it's the Friday a week later. That's what I intended.
It is. It's the Friday.
Friday the 1st of March, so that gives.
We can provide it by Monday, so.
Yes, I'll give you till the 1st of March, Mr. Kuksal. You've just told me this morning how much difficulty you've had with all the time issues.
I have the draft subpoenas ready here.
Okay, but I'm just saying.
But thank you.
And I am going to think and reflect on things. We'll list this for mention.
Your Honor, it shouldn't be listed for mention.
Mention not before the 1st of March, Mr. Kuksal. I'm just saying, you've told me all this stuff. You might be right, I'm not sure. I just want to look at, I've not had this situation, where people are seeking to have subpoenas filed in originating motions.
Your Honor, in any proceeding you don't even need to have a formal court proceeding to issue subpoenas.
Mr. Kuksal, what happens if I look at them and I think they're an abuse of process, and do you want me to just refuse to issue them, or do you?
No, then there can be.
Then we have a mention?
Yes.
All right.
And that's the normal process, so.
What I'm doing is I'm putting today off, so I'm going to list this matter for mention on a date, further mention on a date not before the 1st of March 2024. I'm not going to make any further orders. I'm not going to put in place a series of, I must say I don't accept that it's appropriate to make a series of directions on the assumption that there will be no subpoenas or discovery issued or ordered. I want to get that issue sorted out first.
As the court pleases. And, Mr. Kuksal, you can send me with the draft subpoenas. What was it that you? I'll give you leave or direct you to. What was the document you said? Just an identification of cases or something?
Yes, the appropriate legal principles in relation.
Provide the subpoenas with a document.
Setting out the applicable legal principles.
Setting out applicable legal principles.
Yes, now, Your Honor, may I just say it's the defendant's position that the court, if it thinks prudent, may reserve a date but not schedule a special mention yet and only schedule one in the event that the court considers the subpoena to be an abuse of process.
Well, I'll schedule a mention. I'll just list it for mention on a date not before the 1st of March, and then I'll look at it and I'll decide if we decide that we don't need to come back for a mention for a while. I'll do it we'll take it step by step.
Okay, so then the next, if Your Honor does not think that it's an abuse of process, then that mention will be utilized for the return date of the subpoena or the documents.
We'll see. We'll just cross that bridge when we come to it. There will have to be communications, Mr. Kuksal. The first step, what you're doing is, I suspect, quite a significant step in the proceeding, in that from the way you've talked I'm expecting you've got more than one subpoena and that they're going to be quite extensive in the number of.
But they don't have a say in relation to any other witness anyway.
Yes, but I'm just saying.
And, Your Honor, to be honest, I think it may be that the LSB has discovered all the documents already.
They might have.
So then it's an insignificant step in the proceeding because the subpoena will really not yield anything more than we already have, so it's just a mere formality in the sense that we're reassuring ourselves that we don't have any grievances, accepting that they've done the right thing, so.
All right. Well, I'll do that then.